itself or someone's computer. Those types of searches already require a search warrant. The order that you need to obtain location information specifically states on the order. This order has been issued pursuant to Title 18, U.S. Code Section 2703D, which is the Federal Electronic Communications Privacy Act, which was enacted in 1986 and amended 8 times since then, most recently in 2009. Why is cell phone location data so important to law enforcement? 2 basic reasons. One, to see if someone may have committed a crime, and the other is to eliminate people who probably didn't commit the crime because they were not near the crime scene or the victim during this period of time. By eliminating some people of interest immediately, it frees up law enforcement to spend their valuable time on potential suspects. Those opposed to LD 415 stated that it would go much further than current law, requiring a probable cause warrant when probable cause does not yet exist. For an example that we heard, a homicide took place in southern Maine. The wife claimed an intruder broke into the house. When the detectives interviewed the wife the next day, her brother and a friend were at the house, and detectives were told they had just arrived from New York to comfort her. Based on interviews during the next several days, law enforcement could show specific and articulable facts to obtain a court order to get cell phone information. When law enforcement used the historical location data from all 3 of their cell phones, they found out that the brother's cell phone was pinged off a tower in New York, then in Connecticut, then in Massachusetts, then in New Hampshire, and then in Maine, all on the day of the homicide, not the day after. Now, having probable cause, they could put the 2 of them in Maine on the day of the murder due to this historical cell phone location record. They went back to court to get a search warrant to assess the content of the cell phone records. Lo and behold, the wife and the 2 of them had been talking all day on the trip to Maine, and the friend was really the boyfriend. They had all conspired to kill the husband. The lesser standard of obtaining the court order first allowed them to gather the information to establish probable cause for a warrant and ultimately solve the case. Law enforcement's biggest concern with LD 415 is the notification piece. Within 3 days of obtaining a person's cell phone location information, law enforcement has to notify the person or multiple persons that they access this information and why they were doing it. This jeopardizes an ongoing investigation. They gave an example of a drug dealer who was murdered in southern Maine again, and they have his cell phone with hundreds of contacts on the cell phone, which they pinged off of. Now, do they have to go back to court all the time and notify these people? What if they were friends and they said, gee, somebody just told me you're checking my cell phone? While the bill allows for extensions to this 3-day notification, you have to go back to court to get an order to delay the notification. And the delay only lasts for 90 days. So every 90 days, you would be back in court getting another order to delay notification. That's great if you have one case working in the entire state of Maine. I want to give an example. Actually, one of my good friend's daughter. A young girl from Saco was murdered 7 years ago, and they still have not arrested her killer. If they had pinged some suspect's phones, would they still be going back to court 7 years later to get extensions? Or would those extensions have been denied by now? And would they have to notify everyone that they were on that suspect list? This is just one case. How would law enforcement track all of these extensions on hundreds of cases and thousands of cell phones? Maybe that is why the bill carries a fiscal note of $134,000 per year going forward. Not one instance or example was given at the public hearing where there was an abuse by law enforcement. No problems with the current law having to get a court order recited. We heard a lot of talk about the need to update laws in light of current technology. That may be true, but right now there is no consensus about cell phone warrants for location. Not only do different states and police departments follow different practices, different courts in different areas of the country have ruled differently on this matter. That is why we need to wait to see what Congress is doing to amend the Federal Electronic Communications Privacy Act. Bills are currently pending in both the Senate and House to amend the act that governs these provisions. In light of the recent IRS scandal, amending this federal act is getting a lot of attention. As recently as May 7th, another bill was put in. Updating the federal act will give consistency and uniformity of the law across the country. This bill creates another patchwork of separate state rules dealing with the issue. Even those who want the bill to pass passed out a handout stating that only 4 states require a warrant for this information at the time. I will end the way I started with a quote from the testimony of the Deputy Attorney General. LD 415 appears to be the classic case of a solution in search of a problem. Maine law enforcement and prosecutors are complying with the federal Constitution, the Maine Constitution, and the federal law with respect to location information, and there would appear to be no need for LD 415 to deal with any abuses. I urge you to support the majority ought not to pass.
The chair recognizes the senator from Kennebec, Senator Katz.
Thank you, Mr. President, men and women of the Senate. It's difficult to follow the eloquent remarks of my friend and colleague, Senator Valentino. To me, Mr. President, this bill is about protecting our civil liberties. We come from different parts of the state, from different walks of life and different parties, but we are all Americans. And when you think of the principles that bind us together, that make us different from other places, we are very jealous of our liberty. Here in the land of the free, we value our liberty, and a big part of that is our personal privacy. Privacy from others snooping around in our lives, and particularly privacy from government intruding into our lives. We don't want anyone, including the government, searching our homes, our cars, or our mail without a darn good reason. Now, those rights are not absolute. There may be times when government has a good and legitimate need to invade our privacy, but it ought to be a darn good reason. The question which the Founding Fathers wrestled with 200 years ago was, what is a darn good reason? And then who gets to decide whether it's a darn good reason? The police or someone else? The framers answered that question right in the Constitution, the Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So, what is this probable cause thing that they were talking about? Is it a terribly high standard that it can only be reached in the most extreme cases? Well, it really isn't. It's just a legal way of saying that there's a darn good reason for invasion of privacy. The Maine Supreme Court defined it this way. Probable cause is reasonably trustworthy information which would warrant a prudent person to believe that the search would disclose criminal conduct or items that would aid in identifying a criminal or establishing the commission of a crime. A very, very low standard which no prosecutors have very much trouble in reaching. So, who gets to issue the warrant? And how hard are they to get? Well, they're issued by judges and also by justices of the peace, used to be called complaint justices. There are 50 judges, and I think there are close to that many justices of the peace. So there's close to 100 people around this state available to consider application for warrants night and day. And by the way, those folks who issue the warrants, of course, are only hearing one side of the story. They hear from the prosecutor or the police, not the potential person who's going to be searched. So it's pretty easy to make the case. But the point is, to make the case, they have to show probable cause. Cell phones may be new, but this concept isn't. It's been around since the 18th century, and it's protected us ever since then. There's a well-developed body of law which is built up on the subject, but the basic point is, before our personal privacy gets invaded, a neutral judicial officer must make the call. In baseball, we don't let pitchers call the balls and strikes, and we shouldn't do that either when it comes to the law. The need for protection of our liberties hasn't gone down in 240 years, but what has changed is the technology. Sometimes technology gets ahead of the law, and we need some time to catch up, and that brings us to LD 415. Wiretapping, the ability to secretly listen in on phone conversations, which came up decades ago, probable cause needed for that. This legislature thought that the whole idea of the government snooping around on us on the phone was so problematical that they outlawed wiretapping in Maine. You can't do it under any standard. Now, once again, technology is making us think outside the box. Smartphones. Most of us have them. They are amazing inventions. Not only because I can check the Red Sox score right now if I have a moment, but because if I want to go visit Senator Jackson, 296 miles away in Allagash, it can give me turn-by-turn directions as I go up there. If I'm in the middle of Iowa, it can tell me where the nearest Thai restaurant is in a second. If I'm lost on the streets of New York, it can tell me I'm on the corner of 78th Street and 3rd Avenue. It's mind-boggling. But new technology raises new issues in privacy. Smartphones have pretty amazing capabilities. That GPS function on your phone knows just where you are. Not just that you're in Augusta, but that you're in the State House, and that you're on the 3rd floor of the State House. And if you're Senator Tuttle, you're sitting maybe 10 feet from the window. It's amazing, and it can be used for tremendous good. If there's a child who's lost, if an elderly person is wandered off, it's a wonderful, wonderful tool. But technology is morally neutral. You can use it for bad as well as for good. The fact is that your cell phone provider, whether it's Verizon or US Cellular or Sprint, can tell someone not only where you are right now, but where you have been for the last 30 days or the last 60 days. Did you know they had those records about you? I didn't realize that until recently. Do you feel you should have a reasonable expectation of privacy about where you are now and where you have been the last 2 months? And by the way, who you have been with? Do you feel the government ought to be able to go in and be able to snoop around in those records without your permission and without at least having to show some darn good reason? Just think for a moment about what those records might show. As Judge Ginsburg of the U.S. Court of Appeals recently wrote, he said, it will tell, quote, one's location might reveal whether he is a weekly churchgoer, a heavy drinker, a regular at the gym, an unfaithful husband, a patient receiving medical treatment, an associate of particular individuals or political groups. And not just one such fact about a person, but all such facts. Again, not just where you've been, but who you've been hanging around with. That's the reason we need to ask police to apply to a judicial officer before they can invade that. If that minimal standard of probable cause exists, they'll get a warrant. It's a small step, but one that protects us all. Now, there is also times when the police should not have to go get a warrant, and that's built right into the law. It's when there's an emergency situation. Again, a couple of examples, a child is missing. You don't have to come up and file an affidavit for a search warrant under those circumstances. You just go, the police can go to the cell phone provider and say, there's an emergency here, there's a child missing. The cell phone provider will say, fine, and they'll get those records. The law has always recognized exceptions to warrants for what's called exigent circumstances, which is basically some kind of an emergency. And by the way, if you think of a couple cases recently, that terrible tragedy a few days ago up in Glenburn, that would have been an emergency, a child missing, and issues about whether she might have been abducted, an emergency. All LD 1415 does, Mr. President, 415, is let law catch up with technology and say to the police, if they want to search our incredibly personal information of where we are or where we've been, they'll be held to the same standard as if they wanted to search our mail or our home. Again, we have a reasonable expectation of privacy, and we want to be free from government intrusion unless there is a good reason why not. Consistent with the way other search warrants are handled, the bill does require prosecutors to give notice to the owner of the phone that records have been searched. It's absolutely true. That's just consistent with what happens if someone searches your home. The police have to let you know that they've searched it. But this bill has exemptions to that notice. When the police apply for the warrant, the bill has built in there that they can make the case why giving notice right away would interfere with the ongoing police investigation, and they can delay it for 90 days. And then they can delay it for another 90 days, and another 90, and another 90, ad infinitum. So if there's really truly an ongoing investigation going on that notification is going to interfere with, I guarantee you that no judge is going to deny one of those motions. And by the way, if you don't like those notice requirements, you'll love what you see in the amendment. Mr. President, and by the way, this is also consistent with a recent case from the U.S. Supreme Court I'm sure you heard about, where the police wanted to place a GPS device under the bumper of a car. And the court said no. There's an expectation of privacy in where people are, and before you're going to invade that, you've got to get a warrant. Now, the Attorney General does oppose this law. They tell us that they and the state police are already following rules already, and that's great. But the state police and the Attorney General are not the only law enforcement officers in the state. We have 16 county sheriff's offices. We have I don't know how many dozens of local law enforcement agencies, all of which can go and apply for warrants or go to cell phone providers and ask for records. All this bill does is ask them to get a warrant from a judicial officer. The good senator said that federal law covers this. I respectfully disagree. This law was passed in 1986 when cell phones were just being born. They weighed about 2 pounds. They had no GPS capability, and none of the amendments which have passed since then have updated that. Some courts have said that the federal law applies. Some courts have said that the federal law doesn't apply. And by the way, if you want to wait for Congress to do anything, good luck. It'll be years before they get their act together and deal with this issue, just like they have so many others. I heard it mentioned, not in debate, but that somehow this bill would have impeded the investigation of the Boston Marathon bombing. Absolutely not so. You had a terrorist on the loose. If that's not an emergency which would justify going ahead without a warrant, I don't know what that is. Now, the Attorney General says, trust us. We have more important things to do than snoop around in people's lives. That's the same argument that prosecutors have been making for 2,000 years. And nothing in the Constitution tells us to trust law enforcement when it comes to protecting our privacy. I trust the Attorney General, the current Attorney General. The Chief Deputy Attorney General, the Chief of the Criminal Deputy, is one of my best friends, and I would trust him with my life. And one of the other people you're going to hear today is my colleague from Washington County, Senator Burns, who would also trust implicitly. But my trust doesn't go to all law enforcement at all times. How about the prosecutor down at Duke, elected by the people? 3 lacrosse players at Duke accused of rape. He withheld key DNA evidence that would have exonerated those people. He made false statements to the press to help his own re-election campaign. How about the Arizona cop recently? There were dirt bike tread marks. The FBI had told the prosecutor that the defendant's bike could not possibly have made those marks. And yet the police waited 10 years while this fellow served in prison before that case got figured out. Or more recently, the policeman in Baltimore who outright lied in the search warrant affidavit. Or closer to home, the Hancock County prosecutor recently disciplined for failure to turn over evidence to the defense that might have shown the defendant's innocence. The point is that 99% of people in law enforcement and 99% of the prosecutors are absolutely honorable people. This law is not designed for them. Last 2 weeks, the IRS harassing political groups, the Justice Department snooping into phone records of reporters. It's got nothing to do with what political party's in power. Various administrations are equal opportunity offenders. And the idea that we haven't been able to show a problem in Maine, so what's the need of passing those laws? That's the whole point. When the police do it, they do it in secret. People never know that their records have been searched. This is just trying to get the law straightened out so everybody knows what it is, and not only the Attorney General that acts ethically, but the Assistant Police Chief in East Centerville will know what the law is. Mr. President, it seems to me that one of the most important jobs we have when we come here is to be guardians of the liberty of our constituents. If you don't mind the government snooping around in your lives without a good reason, go ahead and support the pending motion. But remember, as Benjamin Franklin said over 250 years ago, they that can give up essential liberty to obtain a little temporary safety deserve neither liberty nor safety. And I ask my colleagues to vote against the pending motion. Thank you, Mr. President.
The chair recognizes the senator from Hancock, Senator Langley.
Thank you, Mr. President. Men and women of the Senate, I also rise today to oppose the